All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is Publix Supermarkets versus Goga, number 2024-0669. Whenever you're ready.
Good morning. May it please the court. Edward Geddes on behalf of the petitioner Publix Supermarket. With me at council table is my colleague Blaine Udis. Let me dive right into the narrow issue that we have before us today, which is the proper role of an appellate court reviewing the sanction imposed by a trial court for fraud upon the court. In this instance, Publix contends the 4th District overstepped the proper role of an appellate court when it reconsidered the propriety of the dismissal for fraud upon the court, especially when one considers that the 4th District affirmed virtually everything the trial court did in reaching its conclusion that a fraud had been committed by Ms. Goga.
Can I ask you a question? So, it kind of goes to jurisdiction, but it also just sort of goes to kind of what we're here to decide and to do.
Of course.
Reading your brief, and I understand kind of your problem with the opinion, and I understand I understand that it seems like a flawed piece of work, but the way you described the case, it seems like we have to kind of read more into the face of the opinion that's there. So I didn't, and so correct me if I'm wrong about this, I didn't see anywhere in here where the court says that liability was still contested, and I don't see anything about the appeals court sort of purporting to decide, the credibility of the plaintiff. And so it seems like for us to sort of view the case the way you do and kind of set up the rule that you're asking us to apply, we basically have to go beyond what's in the opinion itself. Could you respond to that?
Certainly, Your Honor. I'll invert the two issues because I believe the second one is perhaps easier to address. On the question of the court making what we contend are these fact findings, engaging in fact finding, I think it's evident on the face of the opinion that the court at the 4th District was reaching a conclusion about the effects of Ms. Goga's dishonesty on the entirety of the proceedings, and somehow reaching a conclusion that the trial court never reached. There was never in the record any finding by the trial court about how her dishonesty could be cabined in any way, shape, or form.
In fact, there was a finding directly to the contrary.
Yes.
Because the trial court found, based on the totality of the circumstances and evidence before this court, it has been established by clear and convincing evidence that the plaintiff's lies and deceit permeate the entire case, and that she has intentionally and repeatedly misrepresented herself as overly impaired in an effort to perpetuate a fraud on this court. So there was a specific finding that it permeated the entire case.
Absolutely, Your Honor. Absolutely. You anticipated my next process, my next thought.
Do you agree, though, that for us you wouldn't know from the four corners of the opinion that liability was still contested?
You are correct. There is nothing in the four corners, but
where does that leave us on jurisdiction? Because if I read the opinion, before I knew what was going on, obviously now we have the whole case and we understand that liability was contested and everything. But if I'm going through the exercise at the jurisdictional stage of just reading this opinion, and I see the reliance on the 50 CA case, Jimenez, I guess, and I see the description of that case where liability was not contested, and it wasn't contested that they had, medical costs and whatever, and then I see a case that says, applying the reasoning of Jimenez, we say she can't claim this, but she can claim that. I mean, wouldn't the most natural reading of this be, and it seems like this was a mistake, but if I'm just focusing on the four corners, wouldn't the most natural reading of this opinion be that those things weren't contested in this case either?
I think you can't, well, no, I don't think we can draw we can't draw a conclusion one way or the other. I will concede that point to Your Honor. But our contention isn't that conflict arises because of what Jimenez holds. We contend that conflict arises, and this is the second prong of Cartonis, which is where you have identical facts, or substantially identical facts, and you have diametrically opposed conclusions as to the outcome.
But isn't the liability being contested, isn't that the identity of facts that you're relying on?
But I'm not comparing Jimenez with Goga. I am comparing Jimenez with Willie Kuntz, and now we have the benefit of also the Fifth District's decision in Epps. In both of those cases, in fact, in both of those cases, the exact same argument was raised by the plaintiff, relying on Jimenez, ironically enough. They both said, you shouldn't dismiss, make it a narrow remedy. And both the third in Willie Kuntz and the fifth in Epps said, no, we're not going to disturb the trial court's jurisdiction, or excuse me, the exercise of discretion, because there's plenty of evidence to support what the trial court did, and we're not going to parachute in and change it.
But even in your briefing, you say that in a case where liability isn't contested, that it could potentially be an abuse of justice. And so I don't want to. I mean, I understand that there may be a benefit to this. Seems like just a bad. I don't know what the court was thinking, but if I'm just reading what's here, and if part of the jurisdictional thing and also the precedent, if I were reading this case going forward, I would read this case as standing for the precedent that when liability isn't contested, and again, four corners, because I need to know a lot more from outside the opinion to know why this is as bad as it is, right? If I read just the four corners, I would think, well, we have a case where, based on the way they're using Jimenez and describing it here, liability isn't contested. The fact that she had medical treatment wasn't contested. So you slice off the stuff where the lying is relevant, and for the stuff where it's not contested, you move forward with that. I mean, that seems to me that that's what this case stands for. And for us to kind of do what you want us to do, we have to kind of recharacterize the opinion in a way that's to make it say more than it does.
I think if you look back at, well, I understand the point Your Honor is making, and I think that where the court should be exercising its jurisdiction is to reconcile the outcome here, which I think Your Honor has already acknowledged is difficult to understand, with the correct outcomes that happened in Willie Kuntz and in Epps, based on the same facts. All right, and that's where I think the jurisdiction...
Let's take Epps off the table because, it is subsequent in time. It sounds like what you're really arguing is that we need to answer this question jurisdictionally. Is a matter like this, where liability, say, we can't decide on the basis of the four corners of the opinion what the status of liability is in terms of its degree of contestedness, is it going to come out differently in the third than in the fourth? That is one way for me to sort of articulate the jurisdictional question. It sounds a little bit like you aren't able to give a conclusive answer to that to the chief. I want you, perhaps let's take another shot at it. Is that your argument, that if this case were presented in the third, we would expect it to come out differently than in the fourth?
Absolutely, Your Honor.
Okay.
Absolutely.
And what about the Chief's point about how you might, distinguish on the basis of the absence of a liability finding in the four corners of the opinion? Because I would bet that's what you would argue to distinguish it, right? If you had the same case in the third.
I would. It has, and it is in fact what has been argued. So I'll concede that point that it's not there. But we do have these, and I don't want to go outside. I want to be careful about going outside the record here and what I know is happening with this decision already.
Right.
So, I apologize, Your Honor. I'm not sure that I can. I'm not sure I can directly answer your question, except to say that I think it is. I think it is as fair a conclusion if you look at how Goga, or how the Fourth District describes the case in Goga, leading up to where it cites Jimenez, that it is differentiating. The only thing it picks out as being uncontested, is this question of supposedly the objective medical damages. It seems odd for the Fourth to have picked that issue as being not subject to her testimony because it can somehow be objectively verified, and have ignored or have not discussed, for example, how those damages could have been caused by Publix in the first instance.
That sounds to me more like it sounds like a more complete answer than what you said about it not being in the four corners. You're kind of saying it is in the four corners, but I'm looking at it's like a figure in a painting that casts a shadow, and you're saying that figure is in there because I see the shadow or something like that.
I am drawing my own. The Chief drew inferences about how you read Goga as it's written because they cite to him, and as therefore they must have.
And they don't just cite it; they say, I think they.
And they talk about the
bunch
facts.
of boilerplate about the standards, which you say basically there isn't. Because I'm just trying to figure out what we're doing here, right? Mm-hmm. Error correction versus truly clarifying rule of law, whatever. And so all of this is boilerplate. You say that the DCAs are all in agreement basically about the standards. And then we get to finally the last 3 or 4 paragraphs where they're doing all the work, and they conclude by saying adopting the 5th District's reasoning, comma, blah, blah, blah. And so I then go back to how they described it, and they talk about the reasoning being where when this isn't contested and, we carve out the contested part and we leave the uncontested part. So, I understand. It may be that the world is a better place if we quash this because it just doesn't seem like it's a good opinion. It seems like it ignored sort of what was going on. But if we're being, sticklers about jurisdiction and what we're really doing here, it seems like we're going to have to kind of reshape what the opinion says to get there.
Well, I'm sorry, Your Honor. Go ahead.
Could I ask a question that I think it takes a little different tack than the way you've analyzed it? But what I'd like to focus on is the discrepancy between what the two opinions say about balancing the policy favoring adjudication on the merits and the importance of maintaining judicial integrity, or the integrity of the judicial system. Now, that seems to be the reasoning process that is driving the decision in Goga, this balancing. Now, I don't see that in Wiley Kuntz, and that's actually, they didn't see it either. In Goga, they kind of say, well, they don't talk about that. And I understand you don't rely on that as a basis for conflict, but it seems like to me, when you look at the two opinions, the way they're analyzing it is kind of fundamentally different, because one talks about that and the other does not. One just they talk about other things related, but that when it comes down to that balancing, which basically is the principle on which they are deciding, Goga is deciding it, that's absent from the other case. Why isn't that in itself a conflict?
It is a conflict, and it certainly, and it is, I know, again, Epps comes after the fact, but Epps squarely addresses the balancing of the two policies.
Well, I'm kind of still on the jurisdiction question.
Right, but I think that creates conflict, how the 5th District applies that balancing and how the 4th DCA in Goga applied the balancing are diametrically opposed to each other.
Well, but I think it sounded like what the question was going to was whether the balancing has to happen, and then there's the application. So if you go back to the First Circuit case, which seems to be the fountainhead of this whole thing, and they make the distinction when they're talking about abuse of discretion review, they're making the distinction between, one way for a court to abuse its discretion is to kind of balance the wrong things, or not to put things in the balance, that to not consider factors that would be relevant. And then the next layer of potential abuse of discretion is when you agree, the appellate court agrees that the court considered the right things, but then applied them in a way that abuses discretion. And so I guess one question could be, is there a conflict with this case and some other DCA case at the level of what are the relevant considerations, or does there have to be a balancing at all? And then you get down to the next layer of, okay, assuming that we have to balance and assuming that we agree what the relevant criteria are or considerations, then did we apply it in a wrong way? And it seems like if we get to that level, then there has to be a difference in the facts for there to be a conflict, because you'd have to be agreeing on the test, agreeing on the need for balancing, and then just getting diametrically opposed results in the application.
But look, could I ask this? I think it's a follow-up to what the Chief is saying. In Wiley Kuntz, is that the way you say it?
I've always said Wiley Kuntz, but it could be.
Well, I'll say in the 3rd DCA case, that's the conflict case, the asserted conflict case. Is there really anything about balancing?
No, they do not engage in that analysis.
Okay, so one court is saying you've got to do this balancing, and the other court is just ignoring it. So that seems to me to be a basis for saying that there's a conflict.
But then the irony would be that we would agree with the 4th that you have to do balancing.
Well, we may or may not.
We'll see.
I mean,
we'll see.
I mean, okay,
Counsel,
so
would you think?
We'll just redo the whole test then.
Would you think that perhaps, well, the test is a federal standard, right? It's never really been adopted or mentioned by this court, to my knowledge, the balancing. In fraud case?
Never by this
never
court.
Here. So I think it came from a federal case in the maybe 80s, 90s.
Audie, yeah.
Would you say that perhaps a difference here is that whatever the standard of review is that the DCAs have created, which appears to not exist in any other area of law? I mean, I think in this case they said they applied the abuse of discretion to the legal conclusion. I mean, I don't know any other way, any other place we do that. That's not really, we have abuse of discretion for matters of discretion, and we have de novo for legal conclusions, and we have competent substantial evidence for facts. It's not, this is a very unique standard. Do you think that the problem is, none of the DCAs really agree on what that actually looks like? Problem A. And the second part is that, particularly between Goga and Willie Kuntz, they focused on this sort of stringent review on both whether fraud existed and the sanction in Goga. So they're reweighing, as you said, they're applying this very strict standard, they're applying this balancing test to the sanction. None of the cases from the 3rd seem to do that. They apply that strict standard to the question of if fraud exists, but once they determine fraud, it's just kind of a standard, would a reasonable judge, using the discretion, find the sanction appropriate? And if so, it's affirmed. They don't really have a heavy analysis on that part. They don't do the balancing test. They don't do any of that. Do you think perhaps that is one of the bigger distinctions in the two?
I think that's a fair assessment, Justice Grosshand. If I could maybe phrase it slightly differently, but I think it goes to the same point, which is this idea, the one thing that Willie Kuntz and Epps on the one hand and Goga on the other hand are at odds on is what happens after there has been an affirmance of the fraud on the court.
Because that's
right?
the same in Goga and Willie
They share
Pitts.
that in common.
Yes.
We have
Agreed.
concluded, we have gone through the tests, there has been the evidentiary hearing, we've made the analysis. We are comfortable saying the trial court correctly found there was fraud. Now, what happens at the next step with the sanction that's imposed? And what Goga seems to suggest is that it's not a traditional abuse of discretion standard. You know, what do reasonable minds agree on, don't agree on? It seems to parachute in and say, no, we're substituting our discretion. And the irony is, and we point this out in our briefs, so the irony is, oh my goodness, I'm almost out of time. The irony is that the fourth DCA itself, in prior cases, in Bass, had said, it's not our role, once you get to the sanction, it's not our role to substitute
So can I ask you
our
something
judgment.
on that? In terms of like going to the what are we doing here question, do you see what the fourth DCA and Goga, because they say it's based on the specific facts of this case, but if you look at the analysis, it seems more categorical. In other words, if the intentional misrepresentation and lie, not necessarily misrepresentation, goes to only a category of damages, then the trial court essentially does not have the discretion to dismiss the entire case. That seems to be more of a legally insufficient sort of analysis. So is it truly a misunderstanding of the abuse of discretion standard, or is it the way this is playing out in the district courts? It's they're conflating whether something is legally sufficient to warrant dismissal with the trial court's discretion to dismiss something.
That is a fair characterization, I think, Your Honor, because I think that's it's the only way to explain how they got to where they got. When I say they, I mean the panel below, because they have to have gotten to a position where they thought the trial judge applied the wrong test. Right? When they got to the question of what's the sanction I'm going to impose, they applied the wrong test because, and this I'm reading a little bit into this, is so long as the lie can be tied to a specific issue, it doesn't matter for anything else, and therefore the rest of the case should be allowed to go forward. That's a conclusion they come to. And I don't know how they reached that conclusion given the factual findings that the trial court made, that the fraud permeated the entire proceeding.
Yeah, so let me ask you, because that was another nuance in your briefing, is it seemed like, and if we're going to kind of make the world anew, maybe this can be part of our new test, is you suggested at one point in your brief that part of what makes something a fraud on the court, as opposed to just, oh, they lied in an answer to an interrogatory or whatever, is that by definition a fraud on the court permeates the entire case, which isn't literally, and I know that this quote-unquote test is just something that was adopted from case law or whatever, but
it is, yes.
In your briefing it seemed like you kind of, at points you sort of incorporate that into the fraud on the court test, and if that were part of what the permeating the entire case, if that's part of what the court has to find, and if there has to be competent substantial evidence for that, then it does seem like logically, if the fraud really quote-unquote permeates the case, then I don't see how dismissal couldn't be on the table. I don't even really, I mean, arguably you would have to dismiss the case at that point. But I mean, should that be, is it properly called a fraud on the court if it can be compartmentalized? I mean, so is that another way to slice it?
I think the case law is too inconsistent, respectfully, Your Honor, to say that all courts uniformly agree upon that. I have seen in multiple occasions where the DCAs have said that the fraud, and I think what the DCAs struggle with is, okay, how do we reconcile somebody with a faulty memory, somebody who just doesn't remember something that happened 10 years ago? It has to be serious. Isn't
this what trial courts do all the time?
All the time.
And for me, this is kind of a red herring. Whether or not it can be cabined logically is an interesting academic debate, but in the real world, trial judges do this all the time and exercise traditional equitable powers, and they don't need to cabin it all the time. We don't need to answer that question. The question is, let's accept as a postulate that any lie in a deposition, however minor, is indeed a fraud upon the court, because it is. It's a lie. Okay. The question is it a fraud upon the court of such magnitude that it requires dismissal of the action,
Correct.
which is a separate question and doesn't require this line drawing, and is an exercise in the discretion of a trial court. If someone is bribing jurors, for example, another fraud upon the court, right, that would seem to, eracinate the entire, proceeding in such a way that we'd have to just like dismiss it in a way that a very grievous and repeated falsehood would. I mean, isn't that a better way of dividing the question than to debate whether or not we can cabinet?
I think that's fair, and particularly when you think about how this particular case played out, because what the trial court did correctly was it gave Ms. Goga the opportunity at an evidentiary hearing to come forth and explain her prior testimony. And instead, what the trial judge concluded is she essentially doubled down with her dishonesty, came up with absurd explanations for why she had lied, and that led the trial court to make its factual finding that she is willing to lie to suit her needs, right, pretty much in all aspects of this case.
And isn't it very difficult to see, once you conclude that there's a scheme to defraud,
Yes.
And there are lies, so there's this pattern of lying, which is documented and undeniable, about the extent of injuries and the extent of her suffering. To think that even that sort of lie would not affect the claim for medical expenses just seems to me to be extraordinarily fallacious, because obviously someone who is making up things about their ability to function and how they can perform and how much pain they have and all that will tell consistent lies, most likely, to the healthcare provider that they go to, and they're going to seek treatment. And this is not, obviously, I don't think most people do that who are injured. I think they tell the doctor the truth because they want to get the best care they can get. But we know that people will run up medical bills as part of the overall effort to inflate the pain and suffering damages. That happens. And so to somehow to compartmentalize that seems to be to flee from the obvious reality of what the person would be doing.
If I tell my doctor that I am still in perpetual pain and the doctor then prescribes another 20 sessions of therapy, the bills have been inflated precisely because of that, because I lied to my own doctor about what I'm experiencing. And that's why at its most basic level, the assumption that there's objective evidence of the medical damages just because there are bills is you're right. I think the term you used is correct. It's fallacious.
We can write a 2-page opinion saying that they misapplied the abuse of discretion standard. My problem is, is that what we're here to do? I mean, this is like a second appeal. So you can have, that was semi-rhetorical. So you can have 2 minutes to finish up, and then you can have 3 minutes for rebuttal.
Thank you. I think the court senses the problems that exist with the Fourth's decision. And I understand the court's jurisdictional concerns, but I think there are ways of reaching this jurisdictionally under the broad rubric of Cartonis that lets you resolve this. We very consciously, because of these very complicated issues, we very consciously tried to keep the issue narrow before this court so that it could decide the case on the narrowest grounds possible. Ultimately, at the end of the day, that's your call. But I think there are ways of addressing the outcome here based purely on the Fourth DCA's improper analysis or review of the sanction that was imposed by the trial court and substituting its own fact-finding and its own discretion for that of the trial court. So we respectfully ask that the court quash that portion of the Fourth District's decision and remand.
Thank you.
Good morning, Your Honors. I'm Annabelle Majeski, representing Ms. Goga. If it may it please the court, first of all, I'd like to point out that the Fourth District did not reassess Ms. Goga's credibility, and we are not disputing the fact that there was fraud on the court. I would focus on the fact that of the balancing test. as to whether adjudication on the merits balanced against maintaining judicial integrity. And I would suggest that the balance should be in favor of adjudication on the merits where at all possible, which would go to the fact that she still had a viable claim as to her medical expenses. I don't think that it's
Counsel,
contested.
could you
counsel,
address?
I mean, let me just go back to what I just asked the opposing counsel. I don't see how the lies that we know were told and that you don't dispute. Okay, that
We do not dispute
that's set. The table's set on that. I just don't know how we can logically separate that out and say, oh, that's not going to have anything to do with the medical expenses. Because obviously, a person who has had the good fortune of slipping and falling in Publix, okay? Sometimes that might be viewed as good fortune. Very deep pocket. And then goes on and buys their wine without any obvious indication of any problem. Might decide that this is an opportunity to get some real money and tell some lies about how this fall has affected the plaintiff's life. But the idea that would not have an impact on the medical expenses, I just struggle to see in any sane world where a person who has such a scheme would not carry out that scheme also in the way they're obtaining the medical care. I don't follow it.
Maybe I can help Your Honor. Yes.
I'm in desperate need of help.
All right. So she fell in Publix and she injured her back. She had surgery. She probably had all of those things that she a year later said she continued to have in recuperating. She couldn't lift things. She couldn't, all the things that she claimed she could no longer do. She probably, after the surgery, could no longer do those things. Her lie is to the fact that she lied about the fact that the after effects of the surgery continued way beyond when obviously they did not. So we still have, if you go back to the original injury and the original medical treatment that she had, that can be separated from the continuing effects of the aftermath of the back surgery, which was the result of the injury. I don't think that you would go to the extent of lying and submitting yourself to back surgery and months of recovery just to get money from Publix. I hope that helps Your Honor compartmentalize it a little bit more.
But I mean, even if we look at what you're saying in the most sympathetic light, it would be a pretty aggressive application of abuse of discretion review to say that if you accept the premise that, you have to consider both things, which is what you started with, and you put all this stuff in the balance, and then the court just makes a judgment call as to whether dismissal is warranted. I mean, how could that possibly be an abuse of discretion unless it's uncontested, which is why, if you look at one way of reading this opinion is they compare it to a case where liability and the cost of the plaintiff's medical expenses were uncontested. I mean, you could imagine in that situation, but it seems like that's not the case here. And so given that that's not the case here, how could it possibly be an abuse of discretion for the trial court to have done what it did here?
I guess under the narrowed, to me it seems that the 4th District puts an emphasis on the balancing test and didn't reach the conclusion that the trial court did not do the balancing test.
So do you agree? I mean, do we need to kind of, is the idea that abuse of discretion, and once you get to this point is, could any reason, because there's abuse of discretion at the level of what did you consider, right? But then when you get to applying the correct things, could any reasonable judge have done what this judge did? Are you saying that there needs to be a different test in this context?
Well, I'm relying on the balancing test, and that's why you get different results, because it's fact intensive on each case. as to, the injuries claimed, what the lie does, how does the lie permeate the entire case? And of course, if the lie permeates the entire case and, there's no claim that can be separated out, then dismissal of the entire case should be warranted. And those are the cases relied on by the petitioners, such as Herman v. Intracoastal and the other one. But I'm saying that as far back as Kornblum v. Schneider, the fourth DCA case, that's in 1992, there is a thing that dismissal of the entire case has been upheld when it permeates the entire case, but in others, where the fraud or other misconduct pertain to only a part of the claim, dismissal of the unaffected legitimate part has been held to be too severe.
Well, okay, so let's just break this apart. In your view, the obvious finder of permeation is the trial court judge, right?
Yes.
And is that a question of law or fact or both? The question of permeation. Well,
it's a question of fact to the point where the appellate court determines whether there was substantial competent evidence.
Right. Well, but I'm talking about the trial court's finding, right? Let's take and put aside the fact of the lie, right? Now the question is it a lie that permeates through the case, right? I'm asking you what kind of determination is that? We agree that it resides with the trial court. How does the trial court make that decision in your view? What's the work that the trial court does?
Well, of course, they're assessing credibility and all that.
Well, no.
I think it's
assessment
still an abuse of
credibility
discretion.
goes to the lie. Okay, so we're done with our credibility assessment.
Okay.
Now the trial court is deciding whether or not the lie is so severe that it permeates through the case. Now my question is, what is the mental labor of the trial court in making that finding?
I think it would be more a question of law.
Okay, so now we get to, let's assume the trial court makes a finding of law that the lie permeates the case. That is now on review, right, before the district court.
Correct.
Why is that not subject to just de novo review?
Well, if it's a question of law, then yes, it is de novo review.
Isn't that much more simple than the mess that we're currently wading through?
Yes.
Okay.
And even more simple than the narrowed abusive discretion standard, which we applied to see whether there was fraud on the court.
On the narrowed abusive discretion standard, what's the ultimate source of that?
I think the ultimate source of that is it goes back to the constitutional right to redress of injuries and access to the courts. I think that's what made it a narrowed abusive discretion.
I mean, what court did that come from?
That one I can't answer that, Your Honor. I don't know for sure. It's just that it's been around for a while, and
I believe it was the 5th DCA.
There also was a very learned second DCA opinion that I think talks about the narrow abusive discretion.
well,
I think we had precedent that
I think this is one
that
that's the
was
wisdom
following
of the ages. I mean, it's in 1,000 cases.
Why do you see permeation as a legal issue rather than a factual issue?
I'm sorry, Your Honor.
Permeation, whether a lie permeates the entire proceeding, why do you see that as legal versus factual?
I guess because you've already determined what the facts of the case are when you determine that there was a fraud. But then you have to see how does that, if you're applying the fraud to determine whether it affects the entire case, what affects the entire case would be a question of law. Because
So you see it more as a question of law in the sense that if the lie goes to only one category of damages, you can't dismiss the entire case, and that's a legal conclusion that should be applied across all districts versus giving the trial court the discretion to look at the proceeding on a case-by-case basis, fact-by-fact basis, whether this lie and surveillance post-accident would in fact affect a defense of the medical treatment that preceded that. In other words, the trial court couldn't look at the facts of that case and make that determination.
Well, they would have to look at the facts, even if it's a question of law, because it would be the facts that determine how they're applying the law.
But in terms of applying the principle, the trial court would be precluded from dismissing if it was a categorical legal conclusion. Is that your position, that in determining whether dismissal is appropriate, trial court's discretion is bound by this legal sphere, which includes this rule that if the lie goes to only one category of damages, trial court can't dismiss in any case?
I don't think I'm going that far. I think I'm saying that if the balancing of the factors shows that it does not permeate, so somebody has to do an analysis as to whether a finding that it permeates the entire case is correct, and that would, in most instances, be the appellate court. So whether, if they're reviewing, at the moment it seems that everyone's reviewing under the heightened, narrowed abusive discretion standard, and it would be much easier if they said, yes, we agree that a fraud was committed, but as to whether the fraud permeates the entire case is a question of law, because the dismissal is such a death knell and should be used sparingly.
So if it's a question of law, then what is your legal standard to apply to whether or not something permeates the entire case?
Would be de novo.
No, not standard of review. What is the legal standard for whether something permeates the entire case? It's not discretionary, it's not fact-based, so there must be some legal standard that would govern the trial court's analysis, and what would that standard be?
I don't know. I'd leave that to you all.
No, but I mean, so if you finish the sentence, you know, a fraud permeates the entire case when ... Like, what's the ...
I guess when there's no part of the case that can be separated out,
So
that's not affected by the law.
in a case where liability and the amount of medical care is uncontested, would the fraud permeate that part of the case?
If it's uncontested, no.
I mean,
you can
so-
still go ahead and you know, determine what the damages are. Now,
And so, but then if liability is contested, and if the trial court here basically says this plaintiff is such a liar, starting from the minute that she slipped on the soap to picking her kids up without pain, she's such a liar both in the discovery process and at this hearing that we can't believe a word that comes out of her mouth. I mean, doesn't that permeate the case?
well, in that case, if it's found, those are cases.
That's what the trial court in this case found.
Well, they just said that it permeated the entire case.
And they said that she they said, look, the video showed her immediately after the accident she was fine. She was fine in everything. I brought her in here for an evidentiary hearing, and I didn't believe what she said. She's a liar. We can't believe anything she says. It permeates the whole case. Case dismissed. How could that be an abuse of discretion?
First of all, Your Honor, the video that you're talking about is that was in the store that she did walk away after she had slipped and fallen. But pretty soon after that is when she started receiving the medical treatment. When she started lying about what the after effects of the surgery, basically, and of the injury, which surgery and then the after effects of the surgery, was at least a year after she had the surgery.
Did she make any statements about what she experienced at the time she fell and shortly thereafter? Weren't there some? I mean,
yes, she did.
There were some statements there that weren't consistent with the video, weren't there?
Yes, she said.
Okay, so it goes back to the very inception of the whole thing.
Isn't the right answer supplied by Willie Kuntz? The movement must prove by clear and convincing evidence that a party has sentiently set in motion some unconscionable scheme calculated to interfere with the judicial system's ability to impartially adjudicate a matter by improperly influencing the trier of fact or unfairly hampering the presentation of the opposing party's claim or defense. Isn't that the legal standard in the case law that is in the conflict case, but absent in this one?
Yes.
I mean, that sounds like a legal standard to me. Like it is a fraud upon the court meriting dismissal when ... those things are true.
Yes.
Okay.
Yes, it was up to Publix to prove that she had sentiently set in motion a scheme to defraud completely. And my point is, at the very beginning, I don't know that it's very clear and convincing that she set out a scheme to defraud them by, you know, claiming that her back was injured and having back
But that's
surgery.
not what the fourth found. They didn't say that she didn't do that. They affirmed all of those things, right? They just said, oh, we disagree how bad it was, the sanction. We disagree with the sanction. They did not do an abuse of discretion review. They did not talk about a reasonable action of a judge. They just basically said, we disagree.
Yes.
Well, they talk about it, but then arguably they trip at the end and misapply it, because they quote exactly what was just read.
Yes.
It's in here in the fourth. They quote the no reasonable judge standard, and then they get to the end and they do a face plant. And the only way to understand it is that they either just fell asleep at the switch, or I don't know how they could have done this, but if they really thought that this was just like Jimenez, where liability and the medical expenses are uncontested, then it's a whole different thing.
I think the thing here is, as I said, the precedent in the fourth DCA seems to be the balancing of the two policies, and they seem to mostly favor only partial dismissals rather than unless it's completely egregious, as for example in Herman. They seem to favor partial dismissals, and actually this case, this court also has in the past favored partial dismissals. Now granted, they were in discovery cases where perhaps it was the attorney who committed the discovery violations and they didn't want to punish the plaintiff. But
Well, that's a pretty material difference.
Yeah.
Wouldn't you say?
Yes.
Then,
But what I'm saying
it
is,
sets that all apart from a plaintiff who just lies.
yes, Your Honor, but what I'm trying to get at is the fact that there is that initial understanding that some cases are subject to only partial dismissal and not the whole thing. I'm not saying that they were comparable.
And would you agree that the third DCA does not take this approach? Because Willie Kuntz, this was the very thing argued. They said these fraud doesn't touch these two separate things. Please, they shouldn't have dismissed the whole thing. And they did not apply a balancing test. They did not even mention it. They simply said, they used the abuse of discretion standard and said, we think a reasonable judge would have done a similar sanction, or we don't find it unreasonable, this sanction. So would you agree that that is not, while the fourth DCA might do that, that is not what the third DCA does?
No, the Willie Kuntz gives lip service to the fact that they did the balancing test, but they give us no facts about it, and they give no indication as to why they thought.
Does it even mention the balancing test? I don't know that it does.
I think they mention Jimenez, and
that's okay. You're good. You can keep going.
And
Question
they
on-
I think just
when liability isn't contested, why is that? Why would that be a basis to, only authorize a partial dismissal? I think you can agree, there's several cases where liability isn't contested, but you still get zeros across the board. So why even in that circumstance would it not be a legally permissible sanction to lying, to conclude that it permeates the entire case even when liability isn't contested?
well, it depends on the nature of the lie in those cases. How the lying affects all of the claims is fact intensive, and it depends on what the facts are. What did they lie about, as to, and what is their claim? You do have to have an analysis of those factors. That answer.
Mm-hmm.
I have just enough time to thank you all for your time and to urge you to affirm the fourth DCA, and perhaps, if you are so inclined, maybe clarify the role of the balancing test against access to the courts versus judicial integrity. Thank you.
Thank you very much.
The court has been very generous with its time with me. And so I am disinclined to venture off on a series of commentaries. If the court does not have questions of me on rebuttal, I'll merely reiterate that the court should intercede here and fix the problem created by the 4th District's decision, which creates a horrible incentive for litigants who lie.
Do you prevail under the Willie Kuhn standard?
Yes.
Why?
I'm not sure I understand your question.
Explain. If the standard is the movement must prove by clear and convincing evidence that a party has sentiently set in motion some unconscionable scheme calculated to interfere with the judicial system's ability, essentially, to find truth. How is it inevitable that you prevail? Why isn't that why is the 4th not within its power to say the trial court failed to do that here?
But the 4th didn't. The 4th concluded that the trial court correctly found that there was fraud upon the court, that it met this test.
Well,
and
it didn't apply this test.
Well, it references it. I think Justice Muniz points
this out. Take us right back to where we began, because then we don't have a conflict, right?
No,
Well, there's two tests. There's that, and then there's the balancing adjudication on the merits with access to the courts, right? There's two types of tests.
Yes, there are. And then the question of what's the correct test to apply in the last phase regarding the sanction, which is what I thought I had narrowly hoped to conscribe the appeal to. So,
but the balancing, I mean, so there's the factual question of what did the person do, right? Was there a lie? And then the balancing thing is just you could just sort of skip from, okay, I found that there's a lie, and then the judge is just kind of at sea as to, okay, then what do I do about it? The balancing thing is really just sort of filling in that middle step of, okay, well, now that I've found that there was this fraud on the court, how is my discretion going to be bounded, and it's just sort of trying to kind of summarize these categories of sort of what the criteria are. I mean, there has to be, I guess we could just sort of come up with a new thing that says all you do is you find if there was a fraud, and then the court just kind of does whatever it wants, and it just kind of explains itself, and then we just see if there's some sort of explanation that makes sense to the reviewing court. But I mean, you don't challenge. I mean, in your briefing, you say basically all the DCAs, everybody agrees that there is this kind of middle step of, okay, here are the things that are relevant to a court's consideration of what the sanction should be, right? So you're okay with that. And is there anything that you would add? I mean, the test, the way it's been described, it just sort of talks about, on the one hand, we got to think about, a person's right to their, a remedy, and then on the other hand, we've got to talk about the integrity of the judicial system. Is there anything else that should be added to that?
Well, I think, at the risk of waxing a little philosophical here, and this goes to the point my friend raised regarding the right to trial, the right to have a case decided on the merits. In the civil litigation context, a plaintiff who comes to the court seeking justice, seeking relief, inherently agrees to abide by the rules. Right? One of those rules is that you do not lie under oath. And so if you come to the court...
Well, that applies to both sides.
Oh, absolutely.
Not just to the plaintiff seeking it. That applies on the defense side, too. They're subject to the same rules.
Absolutely. And both sides have to play by the same rules. My point is that with respect to the plaintiff anyway, the plaintiff is actually coming to the court in starting the process. They are invoking the system. And to suggest somehow that anything you do within that process that is dishonest gets a free ride if you can somehow squirrel it away to some unique little bit, I think undermines the entire truth-seeking process, which gets back to this question.
This is why I wish somebody had briefed this as an unclean hands case, but all right. They don't pay me to do that anymore.
But there is that element to it, right? the right to trial can be waived, and it's waived frequently. And if you come into court and you say, I want relief from this system, and then you lie throughout the process, and when you're given an opportunity to explain yourself, you lie again, I think the work is done. The trial court, the trial judge, and they do this day in, day out in thousands and thousands of cases around the state, make these determinations, these tough choices. And I do not think it is appropriate for an appellate court that has agreed that there was this fraud, this scheme, this conscious scheme to cheat, to undermine the system. I do not think the appellate role is to say, well, yeah, but we think something else maybe should have happened. It creates horrible, horrible incentives.
You can have 30 seconds to finish up.
I want to thank the court for the time. This is a fascinating issue which has not visited this court in many, many decades. But it seems very clear that the outcome here is a terrible outcome, and it needs to be quashed, and it should be remanded with instructions to reinstate the entirety of the trial court's judgment. Thank you.
Thank you very much. All right, we'll now take up State of Florida versus Times number 2024-0647.
Mr. Chief Justice, and may it please the court, Derek Monson on behalf of the state. 3 sources of law require the police to knock and announce their presence when serving a search warrant: the U.S. Constitution, the Florida Constitution, and the Florida statutes. It is well established that the drastic remedy of suppression does not apply to the constitutional violations, but under this court's precedent, it does apply to the statutory violation. Of course, the legislature could provide for that somewhat counterintuitive result if it wanted to, but there is nothing in the knock and announce statutes that purports to require the remedy of suppression, and this court should.
In fact, it provides a different remedy, right?
Correct, Your Honor. Specifically, the search warrant knock and announce statute provides for criminal penalties if for police that engage in willful or unnecessarily excessive violations.
Out of curiosity, does the state prosecute those, or has the state sort of not made the decision to prosecute those and to ignore that statute and to instead rely on the exclusionary rule as the remedy?
I'm not aware of any prosecution that the state has undertaken. That may very well be because this court has provided for a different remedy, which I think is just another reason that the court should recede from those cases adopting that remedy, because when the legislature creates a remedy of its own, that is the remedy that the legislature wanted to impose for that.
Let me ask you about something related, and that is the knock and announce rule in the context of arrests. Is there a legislative remedy for that that's analogous to the one for the knock and announce violations, assuming that understand that counsel thinks it's not really, opposing counsel thinks it's not really a remedy for that, but there's something analogous to the search warrant context.
It's not that I know of, Your Honor. I don't
You
think
probably would know of it.
That's right. So I don't think there's a comparable statute in that chapter to Section 933.17.
So that might affect the way we analyze this. I mean, possibly. Wouldn't you agree? I mean, to the extent that we rely on that, if we rely solely to reach your position on that, the existence of that statute, that might dictate a different result in the context of arrest, potentially.
Yes, I do think that's right, Your Honor, if you did rely solely on the provision of a different remedy in the statute, although we don't think that that's actually necessary to the test, because what this court has said, I mean, the question of whether the exclusionary rule applies to a statutory violation is simply a question of statutory interpretation. And what this court said in Jenkins and in Lukehart is that if the statute does not expressly provide for the remedy of suppression, then the court should not read that remedy into the statute.
So should we, and I think this is where I think it's an interesting issue, though, because do we sort of put ourselves back in the shoes of Justice Terrell from 1960, whatever, and decide were they right about the court's authority to kind of imply this remedy? Do we, like, how are we evaluating that decision? Because they obviously weren't sort of purporting to kind of interpret the words of the statute. It seemed like it was a combination of the statute and then plus whatever they understood sort of the judicial role to be there to kind of figure out what to do if there's a violation. And then, 60 years later or whatever, we're going to come along and say what? Are we going to say that your interpretation of the statute was clearly erroneous? Are we saying that it's not really a statutory interpretation question, but are kind of the way, the judiciary sort of created this remedy and so we can take it away, and kind of punt it back to the legislature? I mean, how would we be explaining ourselves to change the status quo that has been in place for 60 years or whatever?
So I think that you could say either. So the question, again, when we're talking about a statutory violation, is a question of statutory interpretation. And regardless of whether you think the court in Benefield misinterpreted the statute or misinterpreted its role as a court and didn't even purport to be interpreting the statute, I think either way, you could say that it was clearly erroneous for them to even go down that track. The only other thing I would note, in addition to the statutory text, is the historical context surrounding the adoption of this knock and announce statute. So
going back to Benefield, how much of it do you think was purely constrained to a remedy for a violation of statute, and how much of it do you think was more of a holistic, was the search reasonable, without really saying they were doing a constitutional analysis, but going back and citing to whether or not a search itself was reasonable versus in the context of not having a warrant versus a knock and announce statutory violation in the context of a warrant?
I think that's a fair point, Your Honor, and that is something we raised in the brief. So I think Benefield is a little unclear on whether it's addressing a statutory violation or whether it thinks the statutory violation rendered the search unreasonable for purposes of the Fourth Amendment. And it's plausible to read it as a Fourth Amendment case that they were applying the Fourth Amendment exclusionary rule, which would have been abrogated then by the U.S. Supreme Court's decision in Hudson.
So if we receded, and it's also, it pre-exists the conformity clause and all sorts of other things. So if we were to look at this as whether or not we're receding from cable, do you think we need to explicitly recede from Benefield, given how different the analysis is?
I don't think you need to. You can certainly you could read Benefield as a Fourth Amendment decision, and then you could say that cable was clearly erroneous in interpreting it as the question of statutory interpretation, and then also then the statutory analysis that Cable purported to do, which I don't know if there was much of any, because it just invokes stare decisis. That was clearly erroneous, and you could then recede from Cable. We think that would also that would be a perfectly reasonable way to do this. In the last point on this, the exclusionary rule, the knock and announce rule, is a common law rule that has existed for centuries. The exclusionary rule was not ever understood at common law to be a remedy for a knock and announce violation. In fact, the common law had no exclusionary rule at all. Normally, when a statute codifies a common law rule, we presume that it brings the common law soil with it, which would include any mechanisms of enforcement. And the fact that this statute was adopted in 1923 before this court had ever even adopted an exclusionary rule for Fourth Amendment violations, and the exclusionary rule in federal court was a relatively recent invention at that time as well that had not been incorporated against the states. There's just no evidence to support the notion that the legislature was withdrawing from decades of common law practice when it codified this common law rule. And so then the only consideration left under this court's stare decisis test, as announced in Poole, is whether there are sufficient reliance interests that warrant standing by the clearly erroneous precedent. And this is precisely the sort of evidentiary rule that this court has said usually does not have any reliance interest. People don't ordinarily order their affairs around evidentiary rules. When Mr. Times here committed his crimes, he had no idea whether the police were going to comply with the knock and announce statute. And even if he did, I'm not sure a reliance in committing crimes is the sort of reliance interest that this court would ordinarily protect with a stare decisis test. If your honors have no further questions, I will leave any remaining remarks for rebuttal. Thank you.
Thanks.
Good morning. May it please the court. My name is Kevin Alvarez. I'm here on behalf of Keith Times. I think the time frame is important to get right because I think it's important to the analysis of the statute and the remedies. I would fully concede that if this was a newly enacted statute, I lose because it doesn't list a remedy in the statute. But I don't think that we should analyze remedies of statutes that were enacted in 1923 through 2025 lenses and vision. And so what we have first in 1914 is when the federal government applies the the federal courts apply the exclusionary rule, the federal exclusionary rule. And then we have the decision in Atz versus Andrews, at least in the opinion that provided relief, understanding, and I apologize, reading older cases is sometimes difficult. I think it may have been more of a plurality opinion than a majority opinion.
Well, it was a two-person opinion.
A two-person opinion with then some issues on certiorari jurisdiction.
If I understand, I mean, you agree that the opinion that you're relying on was joined by the author of the opinion and one other justice.
Yes, sir, but it's not the only opinion that I'm relying on. But yes, that it only has the.
Well, I'm talking about Atz too.
Yeah, yes, sir. And Atz is the opinion of the Chief Justice joined by another justice, and the chief.
Well, and what that amounts to is not that different from an inkblot.
Yes, sir, except I would note, though, that what you have is this discussion that's taking place, and
there's a lot of discussions in the world that don't constitute judicial authority.
And I recognize that, and so we have in 1922, we have Atz, we have the writings that had there been the introduction of illegally acquired evidence, it would have been reversible error, and the forcefulness in which the Chief Justice wrote his opinion, it seemed like that would be an accepted practice.
I've read a lot of forceful minority opinions that might bear fruit years down the road, but they as authority, it means nothing. The forcefulness of it means nothing.
And I recognize that, but then we look at 1924. Where we have the Jackson decision talking about the requirement of strict reliance in the search warrant statute. We then have Hart in 1925 applying the exclusionary rule to a violation of Chapter 933. And then we have in 1946 Johnson, which I agree didn't grant relief in the knock and announce context, but it discussed and reviewed a motion to suppress. and the lower court's denial of a motion to suppress on a knock and announce violation. And while it held that suppression wouldn't be granted in that particular case because the court had made factual findings determine that there hadn't been a violation of the statute, the court didn't say, well, we don't review knock and announce violations as not having a remedy.
We're considering this from a methodological standpoint, though. Why would we focus on a string of federal opinions, some precedential authority, some not, when we have a common law background that Florida statute says is what our statutes are based on that don't apply this exclusionary rule? Why do we ignore that in favor of this kind of limited line of federal precedent?
Well, so the cases that I was citing are Florida Supreme Court cases, so they were a line of Florida cases, and I think that it's fair to assume that the legislature, when it enacts a statute, is aware of what the law is that this court has issued at the time that they're enacting a statute. And so I think it's fair to assume that the legislature had read those opinions, and in 1923, all they had was the benefit of arts. And I understand that if it was a majority opinion, I'd be in a much better position than if it was just that.
Well, counsel, I mean, the idea that you're relying on that, I mean, that's, with all due respect, not a serious argument. That's authority, and that is anything other than somebody expressing an opinion. That's just not authoritative. There's no view of the way courts make authoritative decisions that would identify that as any sort of authority. I mean, don't you agree?
And I recognize that from 1922. I absolutely agree and understand and agree with that, but then we have to deal with Hart in 25, dealing with a violation of statute of 933 2 years later. And so the point that I was making is that this idea that illegally obtained evidence should not be admissible in Florida courts was not some sort of new idea at the time that the statute was enacted. It at least got some writings from this court prior to the enaction of statute, and then was applied by this court after the enaction of the statute. And the arrest component of this statute was added, because we have the knock and announce for search warrants and knock and announce for arrest warrants, was in 1939, which was after the application of the exclusionary rule in Hart in 1925. And so I think that's why the time frame is important. And so what we have to assume, because this court's not writing on a blank slate when it makes the determination in this case, you have to assume that.
So you're referring to a case called Hart?
Yes, sir.
Well, is that cited in your initial brief?
No, sir. It's cited by the state in their initial brief. The case is.
And you don't address it in your brief?
I do not. It's 103 Southern 633, and it's cited on page 21 and 22 of the brief of the state.
Okay, thank you.
Yes, sir. And so the exclusionary rule wasn't applied to the federal exclusionary rule was not made applicable to the states until Mapp versus Ohio in 1901. And so these cases that apply exclusion to statutory violations predate Mapp. And since this court's not writing on a blank slate, I think the court needs to, the court would have to find that predecessor courts had clearly erred in analyzing that exclusion would be the expected remedy for a violation of Chapter 933.
If that's the expected remedy, first of all, it's not in there, so
Yes,
we're saying it's expected. Why would they provide other remedies?
Your Honor, I think on a new statute, I agree with the court 100% that if this was a newer age statute and they had provided another remedy, that would then exclude other remedies. And I think the legislature would know when they enact a statute that that's the position that the court takes today. And if they want effect to be given to their statute, then they need to apply a remedy to it in the actual text of the statute. I'm suggesting that's not the understanding that the legislature had in 1923 when they wrote this statute.
How would they have had a different understanding in 1923?
And
it's not in the common law, right? The exclusionary rule is not in the common law.
I don't want to concede that issue because I was of that same opinion too when I initially was doing my briefing, that there was no evidence of it to support. In prepping for our argument, I've done more research, and I'm not actually sure that there was no evidence of the exclusionary rule being applied.
We don't have any in the briefing.
That's correct.
Okay.
I think what you're saying is that the legislature would have had a different understanding of judicial power in 1923 versus now.
Yeah, yes, Your Honor. The rules of engagement were different then, and so when they wrote a statute, they assumed that the court would provide some effect to the statute.
I guess I understand what you're saying. So you're saying because there's cases doing it, the legislature would have essentially conceded that that's what judicial power meant at the time.
Yes, Your Honor. They would know that if they wrote a statute and that statute wasn't complied with, that there would be the judicial remedy applied and I understand that the argument's a little weak that in 1922 with arts that would have put the legislature on notice, but we're looking at a different time period.
Don't you have another sort of pretty serious historical problem with the fact that the exclusionary rule, as developed and articulated in the line of cases that we've been walking through, is about addressing unreasonable searches and seizures. Here we have a warrant. So by definition, this is a reasonable search and seizure. The problem is with the knock and announce rule. It seems to me like the part of the error, if there was an error, in this court's jurisprudence and perhaps in your argument, is not to recognize that the exclusionary rule, as developed in the United States, is a rule about dealing with unreasonable searches and seizures in some cases, in absence of probable cause in other cases, in the Miranda context, in an abuse of an individual's, Fifth Amendment or Sixth Amendment, Fifth Amendment rights, more precisely. But nowhere do we have an articulation of how the exclusionary rule relates to the manner in which a search warrant, which on its face is both evidence of probable cause and of a reasonable search, is executed.
I understand and I think I argue in the briefs that on a Fourth Amendment standpoint, as it's currently understood, I lose. This is all about statutory remedies, and the Fourth Amendment has no bearing on that. And the question is, can the legislature apply or provide additional level of protections for Floridians? States are different.
But they didn't, right? They didn't provide that. There is no remedy in the statute.
I think if that presupposes that when the legislature passed a statute, they would not expect the exclusionary rule to be applied.
But they wouldn't. There was nothing to say they would have in 1923.
In the text, Your Honor,
or
is
in
correct.
history, or in common law, or in any case.
Only the commentary from 1922.
So we're going to assume the legislature may or may not have read that, but I don't think they would vote based on a two-person concurrence.
Maybe not, but then shortly thereafter, with justices that were around at the time in 1925, they applied the exclusionary rule to a violation of Chapter 933. This is the difficult thing in these older cases. I certainly wasn't alive back then. I don't know what the conversations that were going on in the halls of the legislature would. And legislative history, I tried. I went down to the archives and dug through it.
Well, even if you had found it, the conversations that were had in the halls of the legislature probably would not be very persuasive to this court.
Certainly not with today's analysis, but the fundamental question is, what did the legislature intend at the time that they passed the statute? And nowadays we look to the text of the statute, and that's the lodestar for what that's how we determine what legislative intent was. Primarily is what's the text. I'm suggesting that may not have been the analysis that would have been done.
Is there any authority, if you look back at cases from 1911, some from 1898, is there anything to suggest that this court back then considered the text indeterminate of what a statute meant? In other words,
prior to the enaction of the statute.
Yeah. I mean, I'm struggling. What you're arguing is it's kind of a big deal. In other words, that we look at every statute that predates a specific point in time. I'm not sure when your point in time is, but not for what the text means and not what it meant at the time, but for what the legislature would have assumed would have been the case. That's a completely different way than we've ever looked at statutes before. So I'm wondering what in our case law from that time period makes you think that was the methodology, and then if there's something supporting that, when it stops.
I would suggest that once the court in 1925, 1946 is clearly applying the exclusionary rule to those statutes. And we also have legislative inaction. And I know that's not necessarily, the court always considers that to be the strongest argument, but what we have is we have an opinion from this court, Cable, in 2010 in dissent specifically telling the legislature, you can change the statute if you like to, and there's deafening silence from the legislature on that. Not that I could find a single bill introduced.
Would you believe me if I told you that the legislature might not actually hear and pay attention to every pronouncement we make?
I wouldn't disagree, but we do have 67 elected sheriffs in the county that I do think have some interest in the exclusionary rule being applied.
Well, they may very well have other fish to fry, bigger fish to fry.
But I mean, just on the methodological point, though, it's not just a matter of the words in the text. I mean, I think everyone throughout any kind of period of interpretation would agree that when a statute comes into effect, it sort of drops into a sort of surrounding body of law. And it sounds like the problem isn't so much just the idea, just conceptually, that you would look to the surrounding body of law in addition to the text to understand sort of what the quote-unquote law, applicable law is, which could be a mix of sort of the background tradition and the text. But it sounds like the sea into which this law dropped did not include an exclusionary rule. I mean, it sounds like that's the problem for you.
The text does not, and
well, the text doesn't. Nor did the background into which it was placed include the exclusionary rule. I mean, that seems like that's the hurdle. That's the problem that you have.
I understand that that's definitely the problem that I have. It's not a fatal problem by any stretch of the imagination, I believe, because you have cases from that time shortly after the enaction of the statute explicitly applying the exclusionary rule for statutory violations of 933.
Well, maybe they were wrong.
But and that is always a possibility that a predecessor court has erred. But we're talking about a number of different decisions. It's just not Cable. It just wouldn't be Benefield. You'd be looking at every time the exclusionary rule is applied to any violation of 933.
So why do we have to make it that broad? Because really the issue is Cable. Not every time the exclusionary rule has been applied. And so if we craft this opinion from the context of a violation of statutory violation in the context of a warrantless search versus, the Benefield scenario where it's not reasonable at all, it's not a reasonable search at all, why are we kind of affecting this whole line of exclusionary rule cases versus answering the narrow issue, which is whether a statutory violation of knock and announce requires this remedy?
I don't know how you can do it otherwise. Either you find that because the text of Chapter 933 doesn't provide for an exclusionary rule, I don't know how you could craft an opinion without then finding that every violation of 933 that's not a constitutional violation that the exclusionary rule can't apply to. I think logically it would have to go in wipe out the exclusionary rule. Yeah, and I'm not so much talking about violations of 933. I'm talking about, like, for example, Benefield. Yes.
Would you agree that Benefield seems to be going beyond a pure statutory analysis?
I think it can be read both ways, yes. I don't think my friend on the other side is wrong on that. I think you can read it both ways.
Surprised to hear you say that.
Well, and
I mean, it's like the thing says it's a violation of X statute, and therefore the remedy is that. I mean, I know that there was a lot of interesting stuff that preceded that, but.
And it does. I don't want to make my friend's argument necessarily for them. I do recognize it started going into the unreasonableness language that reeks of Fourth Amendment analysis, but I do believe that Benefield was addressing it on the statutory issue. I just am agreeing that it can be read either way. But I certainly don't think Cable can be read another way, and I think the court still would have to agree with my friend to get around Johnson in 1946 that was addressing a motion to suppress for a violation of knock and announce. So it wouldn't just be Benfield's wrong, it wouldn't just be Cable's wrong, it would have to be that Johnson, the analysis there is wrong, and it would have to be that applying the exclusionary rule for statutory violations that Jackson did in 24, Hart in 25 are wrong also. And that's a lot of wrong from judges that were around at the time and would understand the legal landscape at the time. If there are no more questions, thank you for your time.
Thank you. Appreciate it.
If your honors have no further questions for me, I'm happy to waive my rebuttal time, but I'm also happy to ask any other questions.
Doesn't it? I mean, so it seems like this is. It seems like this is, if you look at sort of the spectrum of sort of judicially humble things to do, it seems like this is a baseline that has been in place for a long time, that has been there for the legislature to change if they want. For us to, can you understand, so what is your best, what would be sort of the most reasonable thing for us to say is clearly wrong about the status quo? Whether, and so at least two possibilities would be the statutory interpretation, which really there isn't. Then there's the kind of, what are judges supposed to do when a statute is silent as a remedy? I mean, if we believe that we have to justify doing something different from the status quo by saying that there is a, demonstrable problem with what came before us for this long period of time, what is the most reasonable thing for us to say about that?
Well, I think that you would say that those decisions are clearly erroneous and that they were addressing a statutory...
Could you speak up?
Yes, sorry, Your Honor. I think you would say that those decisions are clearly erroneous because they were addressing a statutory violation. And the mechanism of enforcement for a statutory violation is a question of statutory interpretation that is up to the legislature. And the legislature here has not provided for suppression as a remedy. And just to Your Honor's point on the question of the stare decisis question, there is tension in the court's case law on this about what to do when a statute is silent as to the remedy. You have cases saying that when the text of the statute does not expressly provide for exclusion, that the court should not read that into the statute. But then you have cable that seems to suggest, like, maybe if the statute is silent, courts are free to come up with their own statutory remedies. So I do think the lower courts here are left not knowing what to do, which line of cases to follow.
And is there, where would the, are we asking sort of what the legislature would have understood the lay of the land to be when this statute took effect?
I think that's right to the extent that that's relevant to the interpretation of the statutory text. So I think, I mean, if this... So
we're going to, so this case boils down to us, the statute is from what, 1920 something?
23, yes.
So we're supposed to go back to 1923 and figure out what would the legislature have, A, what did they do in the language of the statute, but then reading that in context of the background law, what would they have expected the remedy to be?
I don't know that the question is what would they have expected. I mean, the question is...
What would the law have been?
Correct,
What
yes.
would an informed reader of the law have understood the new law of Florida to be in 1923?
That's right, Your Honor, which is why I don't think...
And so the reader would have known that there's this explicit now statutory constraint on what law enforcement can do, and there is no remedy for it, or what?
That the remedy for a statutory constraint would come from the legislature in the context of this.
No, but I mean, but the legislature hadn't done anything, so there's no remedy then.
That's right, Your Honor.
So that's what we would be saying.
But there is a remedy.
Yes. So
there is the remedy that's specifically addressed, at least with respect to knock and announce in the search warrant context.
Yes. So there was the criminal penalties were adopted in 1923 as well for the.
Because they were thinking. We know there that they were thinking about remedies.
That's right.
For a violation. It's a little different situation where they don't address the issue of remedies at all, where they're silent, which would be a different, that's not the case we've got, but in some other case that involving the arrest, there you don't have this argument that they were focused on the issue of remedies, and this provision that was adopted at the same time, in the same law, they're focused on the subject of remedies, but they do not adopt the remedy of exclusion of evidence, correct?
That's correct, Your Honor. We would not necessarily have that same argument to a statute that was silent. Although we do, as I noted, we don't think that that is actually dispositive. We think, I mean, this court has cases like Lukehart where the statute was silent as a remedy, and the court said because the statute is silent as a remedy, it does not provide for suppression as a remedy, and therefore.
But do you agree that methodologically, if there is a statute that's silent, we go back to the time? And in this case, you're saying maybe it's not silent. The scheme is not silent, but then we would go back to the time and understand what sort of the body of law was at the time and what the legal effect of this new statute going into force would have been. And it's possible that the legal effect would include that this remedy would kick in, even if it's not written on the page.
I do agree with that, Your Honor. If there was a long history of suppressing evidence obtained in violation of the knock and announce rule at common law, we would have a much more difficult argument to make that the codification of the common law rule did not include that remedy.
Could I press you on reliance a little bit? Let's assume, for the sake of argument, that we're past clearly erroneous. Clearly we just decide that the statute provides for remedy. It isn't the exclusionary rule. Your opponent argues at page 32 of the answer that the state is wrong to suggest that the only reliance interest that matters is the one of the criminal defendant. You've articulated very well that, the person who's organizing his criminal affairs is not, a reliance interest that we care about. But maybe we care about the reliance interest of his spouse, who's ignorant of the criminal conduct and lying in bed next to him, who has a privacy interest in this home, the children, other residents in the home. Can you address your opponent's argument that the settled expectations of those persons who perhaps in the last 100 years have come to expect, as I don't know, perhaps it's, if we polled the world, they might expect that, the police are going to knock and announce before they execute a search warrant. What about their reliance interests? Are their reliance interests irrelevant to this court?
Sure. I don't know that I would say other reliance interests are irrelevant. I just don't know that that is the type of reliance. When we talk about reliance, I think we mean detrimental reliance. So that somebody.
Well, think about it this way. What is the goal of knocking and announcing? Presumably to protect, life, right? And injury,
damage to property. Yes.
Right. So if I'm the son of the defendant, and I'm playing by the door, presumably, I have an interest in hearing, oh wait, there's a noise, let me back away from the door. That's what I want the state to address, is what about those expectations? Are they real? Are they phantasmagorical? Am I making this up? Or is that not part of the logic for the practice?
So I don't think that's part of the logic for the practice, because I think the question is whether people have taken some sort of action or they've structured their affairs around the court's decisions such that if the court were to then recede from it, they would be left in a worse position otherwise. So that's what I mean by some sort of detrimental reliance. I don't think this court, by reliance, has meant that people have just come to expect the rule and they like it. And I don't think that there's any argument here that anybody has engaged in any sort of detrimental reliance, whether it's the defendant or anybody else, that they've structured their affairs around the exclusionary rule applying here. If there are no further questions, I thank you for your time.
Thank you very much. We're adjourned.
All right.